Call the Lord Chancellor to make her statement.
Thank you very much, Madam Deputy Speaker. With permission, I will make a statement on capacity in the criminal justice system. When this government came to power, we inherited prisons on the brink of disaster, moments from total collapse. Had that happened, the consequences would have been apocalyptic. Courts would have been forced to cancel all trials, the police would have been barred from making arrests, and we would have faced the total breakdown of law and order. The last government knew what had to be done. My predecessor, the former Lord Chancellor, begged his Prime Minister to act. But rather than have the bravery to do so, the now leader of the opposition chose to call an election instead. As a result, it fell to this government to take the necessary but difficult action. While they say that to govern is to choose, my predecessors left me with no choice at all. On the 18th of July, just 2 weeks into the job, I announced to this House that we had been forced to bring forward the release dates of some prisoners serving standard determinate sentences, from 50% of time served in prison to 40%, serving the rest of their sentence on licence in the community. Make no mistake, the action we took prevented the immediate collapse of law and order in our country. But with our prison population still rising fast, there is more that we must do to address the capacity challenges our prisons face. And our task now is to ensure that a crisis like the one we inherited can never happen again. Today, I can set out a measure that will begin to address a specific and acute cause of our prisons' capacity crisis, the remand population. As this House will know, prisoners on remand are in our jails but have not yet been tried or sentenced. Because of the historic backlog in our Crown Courts, another element of the woeful inheritance my predecessors handed to me, the remand population in prisons has soared. Today it stands at a record 17,000. That's nearly 1 in every 5 prisoners. As some in this place will know, remand prisoners are an especially acute problem as they are placed in the so-called reception or Category B prisons. Until they are tried and sentenced, they cannot be moved elsewhere in the estate. It is in our reception prisons that we face the most acute capacity pressure in the country. Unless we address our remand population, we could still see a collapse of the system, not because of a lack of cells, but because we don't have those cells in the places that we need them. It is therefore crucial that we bear down on the remand population. Madam Deputy Speaker, magistrates' courts only have sentencing powers for up to 6 months' imprisonment for a single trialable either-way offence, and only the Crown Court can hand down sentences beyond that. Between May 2022 and March 2023, the previous government chose to extend magistrates' court sentencing powers to 12 months. This enabled magistrates' courts to retain more sentencing hearings and meant that they were heard more quickly. It also freed up capacity in the Crown Court to hear more complex cases. However, magistrate sentencing powers were then reduced back to 6 months when, having failed to address the capacity crisis in our prisons, the pressure on prison places became too great. Now, this government has acted to relieve that pressure, and so I can announce that we will extend magistrate sentencing powers back to 12 months imprisonment. On the 28th of October, I will lay a statutory instrument to that effect, which will come into force on the 18th of November this year. This change does not increase the maximum sentence for specific offences, nor does it change the length of sentence that a defendant will serve. Instead, it expands which courts can hand down sentences of 6 to 12 months imprisonment for a single trialable either-way offence. It will enable the system to make more use of magistrates, who are an integral part of our court system, delivering justice swiftly across the country. This measure will also allow us to begin to address the remand problem in our prisons, but it will do more than that too. This government inherited a record Crown Court backlog. Waits for trials have grown so long that some cases are not heard for years. The impact on victims of crime is profound. For some, justice delayed is, as the old saying goes, justice denied, as victims choose to withdraw from the justice process altogether rather than face the pain of a protracted legal battle. By extending magistrates' powers, we will be able to make progress on addressing the Crown Court backlog, and we will free the Crown Court to take on more of the cases that only they can hear. This measure is expected to free up an equivalent of 2,000 sitting days within the Crown Court each year, which will add capacity on top of the additional 500 sitting days that this government funded on taking office. This measure will, in total, see a slight increase in the overall prison population, but by bearing down on the remand population in our reception prisons, we will create capacity where we need it most. This measure allows us to manage our prison population smartly, and it means we can both address our prisons crisis and tackle the court's backlog. Madam Deputy Speaker, when this government came to power, we inherited a justice system in crisis. We took immediate action to avert a total breakdown of law and order. We are now beginning the work of ensuring that this country never faces this crisis again. There will be more that we must do. In the coming weeks, I will return to the House and set out our long-term plan for the justice system. But these new powers for magistrates mark an important step. They help us alleviate the capacity pressures caused by the historic remand population that we inherited and begin to address the record Crown Court backlog that my predecessors handed to me. In so doing, for victims across the country, they will make justice swifter and ensure that more criminals receive the punishment that they deserve. I commend the statement to the House.
Yeah. Shadow Minister Ed Argar.
Thank you very much, Madam Deputy Speaker, and I'm grateful to the Lord Chancellor and indeed to her civil servants for their typical courtesy in giving me early sight of her statement this morning. I'm grateful to magistrates to whom I pay tribute. In many ways, they're the backbone of our justice system and, like juries, root our justice system in our local communities. Their service is hugely appreciated, as is the work of the Magistrates Association, and I recognise their skill and dedication. The Lord Chancellor highlighted the backlog as the context, and as she'll know, in 2010 the backlog in Crown Courts we inherited was 48,000. That was reduced to 40,000 by 2019. We do recognise, of course, it's a lot higher now. The change, a pandemic. She rightly referred to the remand population and significant increases in that remand population. We, supported by the then opposition, during the pandemic, opted not to mass release prisoners as other countries did, and we opted not to cancel jury trials. But of course that led to increases in the remand population, compounded by the effects of the bar strike. Now, the vast bulk of the backlog, of course, is in the Crown Courts, as the Lord Chancellor will know, but it's right to recognise the interrelationship of the Magistrates' Courts and the Crown Courts. So it was with concern that I saw, in the context of the Concordat on sitting days, which I believe had not been formally signed by the former Lord Chancellor at the time of the election, it appears, in stark contrast to what previous Lord Chancellors did, who increased sitting days, we will see a reduction of 2,700 sitting days compared to last year. And I'd be grateful for her reflections upon that. In 2019, there were 85,000 sitting days. Last year, 107,700. This year, the cap appears to be at 105,000. That appears to be the government's choice, but I'd welcome clarity from her on that point. The changes she set out today were characterised by the chair of the Criminal Bar Association, Mary Pryor KC, quoted in The Guardian, as this is a knee-jerk reaction done without consulting, once again, the criminal barristers and solicitors who deal every day with these cases. Given this, there are a number of questions that are begged about this in the broader criminal justice system, given the scope of her statement. I hope she'll be able to answer them. Firstly, has she conducted a complete impact assessment on these changes? Will she publish that and all the modelling on this prior to the statutory instrument being laid? How many are currently on remand? Is she able to share with the House the latest or most up-to-date figure? Reports suggest that this will, in the short term, potentially increase pressure on prison places. Can she say by what amount her modelling suggests that will be? What prior consultation did she or her department undertake with the Criminal Bar Association, the Bar Council and the Law Society before making this decision? What assessment has she made of the impact on the backlog of her decision announced today? What assessment has she made of the impact this decision may have on the number of short custodial sentences passed by the courts. And given she explicitly in her statement referred to her prisoner early release scheme, I hope she'll be able to answer all those questions, but there's one very important question I hope she'll be able to answer on the floor of the House today, just by way of reassurance. Are there any of the 37 prisoners released in error last month still roaming free, or are they all safely returned to prison? I'd just be grateful for her clarification on that, which I think is important. To conclude, Madam Deputy Speaker, we will find out in under 2 weeks whether she has successfully fought for investment and in the interests of justice and the victims of crime in the pre-budget spending discussions with the Chancellor, or whether she has sold the victims and the systems out and conceded cuts to the Treasury. If she has succeeded in securing additional investment, she will have my gratitude and support. If she has not, we will rightly hold her to account.
Thank you, Madam Deputy Speaker. It's almost as if the Shadow Lord Chancellor wasn't, in fact, a minister himself just a few short months ago in the Justice Department. So let me remind him of a few salient facts. So I'll deal with the issue in relation to Crown Court sitting days first. I'm not going to accept any suggestion or indeed allegation from him that this government has cut sitting days or trials in the Crown Courts. That is entirely untrue, as he knows perfectly well, or ought to know perfectly well. I'm sure he can check with the former Lord Chancellor. On the 28th of June of this year, the last government, the last Lord Chancellor, determined how many days the judges could sit this year. Since then, this government has actually increased the number of sitting days by 500. But as there is clearly some confusion here, it is important I set the record straight. Every year, the government and the judiciary agree a number of sitting days and an overall budget to fund those sitting days in what is known as the Concordat process. In June, the judiciary reached an agreement with the former Lord Chancellor to sit 106,000 days in the Crown Court with a total budget of £275 million. It has become clear that there has been overlisting against that budget, with more trials scheduled than the funding allowed for. As a result of that, some cases have had to be delisted, though far fewer than some recent reporting has suggested, whereby it was claimed that around 5,000 sitting days were being cancelled, and I know he had some other numbers in his remarks. In fact, the number, as I understand it, is more like 1,600 sitting days. While misleading reports have abounded, one thing is clear: the Concordat process has obviously not worked as it should, and I can assure the House that the first Concordat process on my watch will be very different, and such confusions will not occur again. He asked a number of questions that relate to the impact assessment of the change that I've announced today. I will be publishing all of the usual impact assessments in line when the statutory instrument is published in the usual way. As I said in my opening remarks, we do expect that there will be an initial impact on prison places, but over time we expect that to come down. We do, of course, have a little bit more space within the prisons because of the action we have taken to stabilise the pressure on prison places, and it is a sensible measure to then take the opportunity to bear down on the Crown Court backlog by providing the extra 2,000 sitting days that this change will allow, but also to bear down further on our remand population. He will know, of course, that the exact numbers are difficult to model because listing is a matter for the judiciary, and of course some of those on remand will ultimately be found not guilty, and some will be found guilty and sentenced, and the whole range of sentencing measures is available to the independent judiciary. But we do expect to be able to make some progress on the remand population, and crucially be able to move people from the reception estate into the rest of the prison estate, thereby helping us to make sure we have the prison places where we need them. And I can also confirm to him that of the 37 people who were released in error because of the sentencing against the incorrect sentence, all are now back in custody.
The Justice Select Committee, Andy Slaughter.
Madam Deputy Speaker, as someone who spent a decade shadowing and scrutinising the previous government's justice policies, I sympathise with the Lord Chancellor over the chaos she has inherited. But the changes to magistrates' sentencing powers proposed may have mixed results. They should ease the backlog in the Crown Court. They may put additional pressure on our overcrowded prisons. My concern is that we do not have robust data on the Crown Court backlog or on the effects of varying sentencing. The government's about to embark on a quick but thorough review of sentencing. Will they use that opportunity to get the policy and the figures lined up?
I thank the Chair of the Select Committee. I think this is my first chance in this House to welcome him to his new position. Let me deal with the issue in relation to Crown Court data. In fairness to the last government, they did discover this error prior to the conclusion of their term in office, and when I came in, I was made aware of the issue in relation to Crown Court data. I ordered further investigation and examination of the issues. It's clear that there are a number of problems with the data. There are a number of errors and other issues which do need to be resolved, and we will make sure that the data is published when we can be sure that it is accurate and that all of those errors have been finally resolved. Clearly, the situation is unacceptable. I am in discussion with the Lady Chief Justice about the need for a full external audit of Crown Court data, because I think we can all agree that the data has to be accurate, and we clearly do have to do more to restore confidence in the reporting process, and I will update the House further in due course.
Liberal Democrat spokesperson Josh Babarinde.
Thank you, Madam Deputy Speaker, and I thank the Secretary of State for advance sight of her statement. So many of my constituents are appalled with the state in which the Conservatives have left our justice system. Huge court backlogs, a woefully big remand population, overcrowded prisons, and so many victims and survivors without justice. So I welcome the Secretary of State's determination to arrest this problem and this decline, especially the reports of her correspondence with the Prime Minister for a fully funded Ministry of Justice. But I want to address some key concerns that Liberal Democrats have with some of the proposals that she set out today. First is on prisons' capacity. She's recognised that in the short term there may be some additional issues there. With the system bursting at the seams, with us being just 100 men away a matter of weeks ago from the prisons being completely full, how will the Secretary of State stop our prisons from collapsing due to these measures? The second is around prison effectiveness. Putting too many eggs into prison's basket will ultimately fail to keep our communities safe. We know that 75% of ex-offenders go on to re-offend within 9 years of them being released. And I know from my work before I arrived in this place, getting kids out of crime and gangs, that rehabilitation holistically is a critical way of reducing re-offending and reducing victimhood. So how will the Secretary of State double down on rehabilitation and through the gate mentoring programmes to reduce offending? Thirdly is in terms of the magistrates' courts themselves. These measures will add more pressure to those courts at a time when many, like my own magistrates' court in Eastbourne, have closed. This risks forcing victims of crimes currently heard in those courts to wait even longer for justice. How will the Secretary of State address this risk? Finally, one of the worst Justice Secretaries in recent memory, Dominic Raab, tried a similar policy in 2022, with magistrates increasing the number of people being sent to prison on short sentences. The scheme was dropped after a year, and we know that short sentence reoffending rates are at 57%, which is a deplorable number. So how will the Secretary of State avoid these measures from backfiring in a similar way?
Those statements should be 2 minutes, no longer. Lord Chancellor.
Thank you very much, Madam Deputy Speaker. I thank the Honourable Member for his questions. Let me say I'm very aware of the numbers of places that we have in our prison estate, and we did have a particularly difficult moment before the last bank holiday in August when we came down to fewer than 100 spaces within our prisons. However, as a result of the measures that we have taken on SDS 40, there is some space and some capacity now in our prison system, and it is important that we also use that opportunity to bear down on the remand population and also to deal with the Crown Court backlog. It is a delicate balancing exercise. It's one that I will be keeping a close eye on and personally under review, but I think that this is the right measure, ultimately because it does help us with our prisons capacity challenges, so that we have the places in the prison places where we need them in the reception prisons, and we can start moving people out to other parts of the estate, which is not possible until cases are heard. I'm confident that we have the capacity in the magistrates' courts to deal with the additional workload. That is something that I will be keeping again under review myself. He is right. It is actually 80% of offenders are re-offenders. This country has a real problem when it comes to failing to rehabilitate offenders, and our record on reducing reoffending is not as strong as it should be. I believe prison has a place. I think it's really important that people who break our laws are properly punished. That is necessary for the public to maintain confidence in our system, and for law-abiding citizens to feel that there are consequences when our laws are broken. So there is absolutely no doubt in my mind that punishment and prison are really important. But I think it goes hand in hand with rehabilitation. I don't think there is a choice to be made between punishment and rehabilitation. They are two sides of the same coin. You have to have both, and this government is determined to have a better track record on both punishment and rehabilitation than anything that has gone on in the previous 14 years. I would also just gently say it was not the case that magistrates' courts send more people to prison. That I think the lesson of the previous changes, because they were able to run through the cases faster and because the previous government hadn't created capacity in the prison estate, the pressure on prison places became very acute, and the measure had to be dropped back to the 6 months, though the Shadow Lord Chancellor, I'm sure, might wish to offer some further comments on that point, but that's actually what happened, and that's what I expect to happen again. Thank you very much.
Stella Creasy.
Thank you, Madam Deputy Speaker, and it is fascinating and powerful to hear the plans to try and deal with the backlog in the courts, and I know that all of our constituents will be grateful for the work that the Lord Chancellor is doing. I have a constituent who was the victim of an aggravated burglary involving multiple men coming to her house with machetes in 2021. Finally, last week at Snaresbrook Crown Court, a date was set for trial for gentlemen who are accused of this crime for October 2026. I know that the Lord Chancellor will recognise and share the concern of my constituent. As she says, justice delayed is justice denied. What comfort can she give my constituent that matters like this will not happen or indeed be expedited as a result of her work?
Thank you very much. I thank my honourable friend, and I'm very sorry to hear about the experience of her constituent. My own constituency caseload has many such cases within it as well, of unacceptable delays for cases to be heard. I hope that the measures I have announced today will begin to ease some of that pressure, because making this change does free up to around 2,000 sitting days within the Crown Court, and this government has funded an additional 500 beyond the Concordat process agreement that was reached by the previous government in June. I'm determined that we start to make more progress on dealing with the Crown Court backlog, so that constituents like us don't have to wait so many years for their cases to be heard and ultimately for justice to be done.
Yeah. Sir Julian Lewis.
May I reach out across the party divide to say that I warmly welcome what the Justice Secretary has just said about punishment and rehabilitation. By coincidence, I've just written to her, she won't have seen the letter yet, about the work being carried out by my constituent, the publisher Andrew Duncan, in coordination with a panel of experts, including a psychology professor, a former governor of Pentonville, a probation service specialist in reducing reoffending, and a central London magistrate, on a new concept of community detention. And my request is that either she or the ministerial member of her team she thinks most appropriate will agree to have a meeting with my constituent and a few members of his team and myself. As a right-of-centre politician, I'm sometimes sceptical of alternatives to prison. This one sounds really interesting, and I think it wouldn't be a waste of her time.
I thank the honourable member for the spirit in which he makes his remarks, and I do hope that where consensus is possible on a cross-party basis across this House, that we are able to work together, because this is a national problem and it will require all of us coming together in order to solve it. I will look out for his letter, I will track that down, and I will ensure that he gets a full response and a meeting as well.
Davies.
In Shropshire, the justice system has broken. Under the watch of the last Conservative government, the remand court in Shropshire Magistrates was closed, transferred to Kidderminster. I'm delighted to say that under this government's watch, remand court's about to reopen. 300 court sessions running empty each and every year at Shropshire Magistrates Court. And the Shropshire Star, my local paper, highlighted a criminal trial which involved a retrial which will take 7 years from the original date of the offence to be disposed of, which is an absolute disgrace. Will the Lord Chancellor look at ways in which we can empower further district judges in the Magistrates Court, and also the use of technology in the justice system? And finally, Madam Deputy Speaker, the use of data. And it's really important that the transparency around this is fixed. The last Conservative government, unfortunately, did not release the data on time, and we need to understand what's really going on now and in the past.
I thank my honourable friend. Look, he is absolutely right. Cases are taking too long to reach conclusion in our courts, and we're obviously making some changes now, and I am considering what further changes we will need to make. I think there is an important piece around efficiency and productivity within the court system, but there have also been previous reports by Lord Justice Auld, Lord Leveson and others which have looked at other ways in which we can speed up trials being heard. All of those options are on the table, and I will update the House further in due course about the approach of this government. I simply reiterate my remarks in relation to the data. It is important that when it is finally published, we can be certain it is accurate, it properly captures what's going on in our Crown courts, and it is data that we can all have confidence in. In fairness, the last government did pick up on this problem. I am determined that it will be resolved and that that data will ultimately be published.
Jim Shannon.
Madam Deputy Speaker, can I thank the Secretary of State very much for her statement. I think it's very much welcome, and there's a clear commitment to the change that is necessary. Often, Secretary of State will note I always, and probably nearly always, focus upon victims. So I can ask the Secretary of State, can she outline what weight is given to victim impact statements, and whether there is a need to determine in law how much weight is lent by the impact on the devastated families? I always think about devastated families. They're the ones that are really important. Thank you.
I thank the honourable member for his question. Let me reassure him we place great importance in the victim's experience. It's something that this government will be addressing further to strengthen and make sure that victims are not further traumatised by their experience of seeking justice. Victim impact statements have an important role to play. My honourable friend, the Minister for Victims, has recently been meeting with victim support and other groups. This is a really important piece of work for the government, and I know he will hold us to account on our track record. I am very aware of the impact on victims of delays in the system. That is why we're making the changes today, and we will make more progress to bring these delays down.
Oliver Ryan.
Thank you, Madam Deputy Speaker. I thank the Lord Chancellor for her important work in tackling the backlog, and her departments indeed. Given the previous government agreed the funding allocation, who does the Lord Chancellor feel is responsible for the number of Crown Court sitting days being cut? And has she explored the further use of AI in small judgments to speed up the backlog? Thank you.
No chance.
Well, look, I reiterate my previous remarks on what's happened in relation to Crown Court sitting days. I don't think it's helpful for me to speculate on who is ultimately responsible. It's clear that the Concordat process has not worked as it should, and as I've said, the first process to be conducted by me as Lord Chancellor will not have these issues. An agreement was reached. The agreement has to be stuck to. All concerned in the system, I'm sure, are worried about the impact on victims. They are are the ones that will be waiting longer. But as I said, although the reports have suggested that up to 5,000 sitting days have been cancelled, the number is actually more like 1,600, and the changes we've announced today will actually free up capacity in the Crown Courts. I am very interested in the role that AI and other technology and digital solutions can play in increasing efficiency and productivity with the Crown Court system, and actually within the court system more broadly. That is obviously something that's subject to discussions in relation to the budget and spending review. I hope to update the House further in due course.
Melanie on.
Thank you very much, Madam Deputy Speaker. I'm very concerned to hear of the mispublication of Crown Court backlog data, and wonder how can we hope to drive down the backlog if we don't know how big it is?
And that is one of the reasons why I am determined to get to the bottom of what's gone wrong, but also to make sure that all errors and issues in relation to accuracy are dealt with, so that we have comprehensive data that we can rely upon. What we do know is that the Crown Court backlog is at historic levels. Sadly, I don't think that any assurance work that is going to be done on this data is going to suddenly bring it down. I suspect it is more likely, in fact, to go up. But it is important that we establish the true scale of that backlog, because this House needs to know exactly what that looks like, and also be able to hold the government to account on its efforts to bring that backlog down. But you can't do that unless you know its exact size. Sadly, I suspect it will remain at the historic levels that we have inherited. I don't think that's going to come down by very much.
Jim Dixon.
Thank you very much, Madam Deputy Speaker, and can I thank the Lord Chancellor very much for her statement. It's very clear from everything we've seen over the last 14 years and since the 4th of July that the last government completely failed to manage our prison estate. But does she agree with me and my constituents that it's really important we maintain space in our prison system to lock up the most dangerous offenders? But at the same time, we do need to have a look at community sentences, and will she be doing that?
He is absolutely right. There must always be space in our prisons to lock up the most dangerous offenders. We must always place public protection above all other considerations when it comes to dangerous, violent offenders. When you have a capacity crisis as acute as the one that I've inherited, you do then have to also, unfortunately, consider other alternatives, simply because running out of space is no option at all. And I reiterate my remarks earlier, punishment and rehabilitation have to go together. It's not a choice between one or the other. They are two sides of the same coin, and this government is determined to make progress on both.
Adam Jogi.
Thank you, Madam Deputy Speaker. My constituents in Newcastle and Lyme will welcome the clarity that the Lord Chancellor has provided today. And with reference to her point about the long-term plan for the justice system, a plan that we have to get right, can I ask her to keep in mind the need for a proper, robust and accessible legal aid system?
My honourable friend is absolutely right. Legal aid underpins our system of justice, and access to justice and stabilising the situation in relation to legal aid is a key priority of this government.
Chair.
Thank you, Madam Deputy Speaker. I have a number of prisons in Doncaster East and the Isle of Axholme, and I was particularly concerned to read about Serco's failures on tagging. Can the Secretary of State say what she is doing to hold them to account?
Thank my honourable friend for his question. Serco's performance is unacceptable. We are having daily meetings with them to ensure that they recover the position. I've made it clear that improved performance is an absolute priority. We are already imposing financial penalties given their performance to date, and won't hesitate to trigger relevant contractual penalties if they do not improve.
Alex Barros-Curtis.
Thank you, Madam Deputy Speaker. May I thank my right honourable friend for her statement and commend her and her ministerial team for the work they're doing fixing the last 14 years of Tory mess in this department. In a statement, she talked about the withdrawal of victims from the process, and on that point, 60% of rape victims are dropping out of their cases, partly because they are waiting years for justice. So can the Secretary of State explain how independent legal advocates will support victims to see their cases through to trial?
thank my honourable friend for his question. The introduction of independent legal advocates for rape victims, we believe, will ensure that the rights that those victims already have will in fact be enforced, and in such a way as to give victims confidence to continue with their cases. This is a key priority policy for our party and for this government, and I will be very pleased to be able to roll this out over the coming months and years. It is a significant change in our legal system. It will be the first time that independent legal advice is given to a type of victim, but we think it's incredibly important because rape victims lose confidence in the process, are often re-traumatised by the process of seeking justice, and independent legal advocates will try and ensure that the scales of justice are rebalanced and they have a fair shot of having their already existing legal rights enforced.
Goldsborough.
Thank you, Madam Deputy Speaker. Prisons have two vital functions, that is punishment and rehabilitation. Reoffending has gone up, and the reason why is because after 14 years, the actual prisons have become colleges of crime under the Conservatives. We need to get the basics right. We need to get the fundamentals right on prison education reform. Going forward, will my right honourable friend look at that issue to look at how we get literacy and numeracy skills improved in our prison estate?
We will, of course, look at improved literacy and other skills within our prison estate. The problem with running a prison estate as hot as the previous government did and so full to the absolute brim is that when you are so badly overcrowded and prisoners are locked up for 23 hours every day, there is very little other work that you can do to help prisoners rehabilitate. And so dealing with the capacity crisis will enable us to have a better performance and better track record on rehabilitation, which is crucial if we are ultimately to reduce the number of victims in future and cut crime.
Final question, Babarinde Just.
Thank you, Madam Deputy Speaker. Does the Secretary of State agree that by failing to address the prison's capacity crisis and allowing the Crown Court backlog to grow to unprecedented levels has meant that the entirety of our criminal justice system has been broken, and I make particular reference to rape and serious sexual offences cases? Thank you.
It's clear that the position that I've inherited from my predecessors was shocking, completely unacceptable, and we were simply one bad day from total disaster within our criminal justice system. That is why we have been making, since we formed the government, the difficult choices necessary to stabilise our criminal justice system, to stabilise the situation in our prisons, so that we can restore this system to one that the public can rightly have confidence in.
That draws that to a conclusion. I'll give the Lord Chancellor on the front benches a moment to shuffle as we get ready for the next